All rise. The Court of Appeals, Division 1 is now in session.
Thank you, folks. Have a seat. Apologize for our slight delay. Court construction. Not always in our control. All right. So we are here in 1 CACV 220626, HazMat Response Technologies, Inc. versus Oxnard Commerce Flex, I'll get that out, LLC. It is the time set for oral argument. Each side has 20 minutes. We will be arguing from the podium today. You will see the timer on the podium. The timers count down. They will include all your time. So if you were to tell us that you're reserving a certain amount of time for rebuttal, we do not adjust it. So you're responsible for keeping track of that. In terms of the oral argument, we do have the 20 minutes. You are welcome to use all of that time. You don't have to. I would encourage you to focus your argument here today on what you view as the critical issues. We have read the briefs. We have conferenced the case beforehand and have discussed it in great detail. So a rehash of the briefs usually is not a helpful approach to oral argument. With that, counsel, if you are ready to proceed. Oh, I should add, and I apologize, we are taping and broadcasting these proceedings, so when you do start, counsel, state your name and identify the party you represent for the record.
Yes, thank you, Your Honor.
Yes.
Good morning to the panel, judges, this morning. My name is Greg McGill. I'm counsel for the plaintiff appellant HazMat Response Technologies, and I'm present with co-counsel Ryan McGill of my office this morning. As Your Honor just indicated, you're familiar with the briefs and the record, but I thought I would start out with what I'm not going to argue this morning, which is I'm not going to ask the panel to superimpose, its view on the matters that occurred at the trial court. I am asking the panel to determine whether there was a manifest abuse of discretion with respect to what we assert was the jury's failure to adhere to two very important jury instructions on the law in the case. And those two jury instructions were, number one, and this is a rule of construction that I'm sure Your Honors are quite familiar with. It's a secondary rule of contract construction, but it's an important one in the event that a contract, and here we have a commercial lease on a lockout situation, on a purported breach of payments on the lease in September and October of 2018. The rule of contract construction, you would get to the secondary rule of construction, which is, and this is one of the jury instructions that I referenced a moment ago, construed against the drafter. You get to that one if in the first instance, if the contract that was prepared and written, here in this case, it was undisputed, it was written by the commercial landlord, is ambiguous in any way or contains a key term that's not defined in the contract. Now, that may have been a major defect in the draftsmanship of this commercial lease, but my client, who is a viable, profitable business for HazMat Technologies, should not have borne the damage from that, meaning the instruction, the jury instruction, and construing a contract against the drafter we submit was not adhered to by the jury at trial. Now, there's a second part to that. Yes, sir.
Well, counsel, you didn't state the law exactly as it was stated in the jury instruction. I don't think there was an objection to the jury instruction as it was given. So what the instruction said, and I think is accurate, is if and only if you have determined and considered the facts and circumstances surrounding the formation of the contract and still cannot determine which of the possible reasonable meanings was intended by the parties, you should apply the following rule, which is the adverse inference against the adverse reading against the drafter. But you only get there if the jury can't figure out what it meant based on the evidence presented. You said that if it isn't defined, that's not an accurate statement from my perspective.
Well, the court is noting that there was an evidentiary basis for that, a threshold determination by the jury based on the evidence. Let me go to that.
If they could find it based on that evidence,
Sure.
they didn't have to get into that adverse instruction.
Right,
The
I
adverse
understand.
rating, the second part.
That was going to be the second part that I was going to address, Your Honor. I appreciate you bringing that up, because there is that second part, which is an evidentiary part.
So why don't we assume, we tend to affirm jury verdicts, that the jury followed the instruction, and we could
Okay.
easily just find that the jury decided that the term concealed meant that in this case, the water heater wasn't concealed.
The reason is, and this is why the spoliation issue is very important. There were two jury instruction issues that I raised on appeal. One is this secondary rule of construction that we're discussing right now, construe against the
Well, let's
drafter.
assume we don't agree with you on the spoliation. I'm not
Well-
suggesting you don't talk about it. If we don't agree with you on the spoliation, does this matter at all?
Well, I think, Your Honor, if I could, the spoliation, the reason that that's so germane to this, on this rule of construction, because the two issues in paragraph 6.03, and this is what puts the obligation ultimately on the landlord. It says if the electrical, mechanical, and plumbing is concealed or deals with an item that's used in common by the tenants. So that would be the lines and valves, for example, that run through the building. So either the equipment is concealed, or if it's used in common by other tenants, meaning the water lines that run through the building. Because Murray Demlow, their mechanics.
If the water lines were leaking, but here it was the water heater.
Okay, well, and that goes exactly to my point. Your Honor, you just said respectfully here the water heater was leaking. When Judge Viola denied summary judgment, this goes to the spoliation that you just asked about. The spoliation is really important on the 6.3, the construction of the contract, because without the equipment, and we had 15 months to go into discovery, this is a sophisticated interstate commercial landlord. During litigation, they just threw out all the equipment in a case that dealt with causation on the equipment, water causation.
Counsel, I didn't want to interrupt
Yeah.
my colleague's
Sure.
question here, but I have, since you're pounding the spoliation part a little bit, I had some questions for you about that.
Sure.
So this case was filed, like something November 2018? When was it filed?
Yes.
Okay.
Yes.
And so the hot water heater got ripped out 10 months after that, right?
I believe so, right.
Did the parties not exchange initial disclosures less than 10 months before, after the start of the case? I mean, when was the initial disclosure in this case?
That was, I believe, there was a TRO hearing, Your Honor, in late 2018, and then there were some disclosures exchanged. I think it was in the first quarter of 19.
I guess this is, from the commercial litigation standpoint, anything that you can obtain through discovery is obligated to be provided in disclosure. It's the same standard in Rule 26 and Rule 26.1, same standard. So if it was such a big deal that they hauled this item off 10 months into the case, why wasn't there already disclosure practice to seek to preserve it? So if it wasn't in their disclosure, why aren't you asking to preserve it? And if it was in their disclosure, isn't it really on you guys for not demanding the preservation of the object and to inspect the object less than 10 months after the case started?
Well, Your Honor, I've got a couple of answers to that. The spoliation the burden's was not on us on the spoliation. You know, spoliation, and this is under this CR1 case.
Well, but my question goes to the materiality of it. I mean, if it's like, you know, the log books at Guantanamo and A Few Good Men, you probably wanted them, you know, sooner than 10 months into the case, right? I mean, if it's that central to your trial, it sheds some light on the materiality of what you're seeking that nobody exchanged like a disclosure press for it. Like, where is it? Can I see it? You know, was there a request to preserve it in the first 10 months of the case?
Well, that's my point, Your Honor. And this goes in our opening brief. It's on page 26.
By lawyers. Did a lawyer ask to preserve this object in the first 10 months of the case?
The duty for preservation of evidence kicks in. It's automatic. As soon as there is either a demand letter in anticipation of litigation or as soon as a lawsuit's filed, there's no demand that one party has to make on the other for preservation of evidence.
And I can ask your colleague here, but just was the water heater disclosed? Was it disclosed as a piece of evidence in the initial disclosures in either your statement or theirs?
Well, I believe the answer was yes to that because both sides were talking. That was a focus point of the causation issues early in the case because 6.03 in the contract, which puts the liability on the landlord, focuses on that mechanical equipment, which was the hot water heater, the lines, and the valves. What's astonishing, frankly, it's really stunning in its import, is this commercial landlord during the litigation that's involved in interstate transactions in a case dealing with the causation of the water, which goes to who's responsible for the water bills, which cascaded down, not to use a pun, but it cascaded down to who's responsible and who caused the breach and whether the lockout was justified. The evidence on causation during the case with 15 months to go in discovery, the landlord just threw it all out and said, well, in mitigation, we changed tenants, and they threw out all the evidence with 15 months to go in discovery.
Counsel, where, in our record, where are the disclosure statements? Did they get filed?
Disclosure statements typically do not get filed into the record, and when we went to trial.
But we have here an issue that you're raising here about spoliation, which is, you know, there are a couple of, the test for spoliation includes an intent element, does it not? So where is the notice, hey, keep this stuff around, and then the disclosure that says, yeah, we've got it, and then the subsequent proof that it was thrown out in bad faith?
The CR1 case on page 26.
I'm not talking about the CR1 case.
Okay,
I'm talking
case,
about establishing the notice.
We don't have the obligation. We had no duty to give them notice to preserve the evidence. It's automatic duty.
But we're talking about appeal. I mean, our review is not on the we don't review facts. We review records.
Right, and we have.
I'm sorry. We don't redetermine facts. That was poorly phrased.
Sure.
But we're stuck with the record that we have. So when an appellant doesn't include all elements of a record to prove their position, the case law says that we're not supposed to interpret that contrary to what juries decide.
Well, we do have it in the record because there were motions. I filed motions for spoliation. That's in the briefing. I made reference to it, and Judge Viola ruled on it. And I asked for a negative inference instruction, which is the least draconian remedy. If evidence on a causation case like this, and it was undisputed, they discarded it. They just said we didn't discard it intentionally.
Counsel, undisputed that they discarded it isn't enough to get a negative, the spoliation inference. The standard is evidence of bad faith and the inability to establish what the evidence may have shown, and that was on your client's burden to prove. And so the question is, what your evidence of bad faith appears to be they knew there was litigation, and 10 months into it, knowing that they also had to mitigate, instead of preserving evidence and perhaps not mitigating their damages, they removed the water heater and moved forward. Is that a fair summation of what you're saying?
No. What I'm saying
Well,
is.
then what's the evidence of bad faith?
Okay, Ashton v. Knight.
No, I want to stay with my question.
Sure, the evidence of bad
The
faith.
Superior Court only has to give the instruction, in fact, only should, if your client comes forward with evidence of bad faith and the inability to show it. So evidence of bad faith, and then I want to get to the inability.
Okay, the cases that I cited in my briefs in Arizona.
Here, this case.
Right, in
Bad
this
faith.
case, bad faith was that they knew that this case involved causation. Here's the bad faith. At trial, they ended up putting Mark Kellner, who was not present, but he was one of their managers, on the stand and testified about the causation. And when they did that, that aggravated and exacerbated the issue because they put him on there. He wasn't there at the time. He showed up afterwards, 45 minutes late. So he's testifying about causation. He's saying there's one leak, it's at the top, on the line, and he went that way because he's arguing that that's not concealed because you can see the line from the floor. Murray Demlow testified in deposition and at trial. He said, and he's their maintenance tech who was there at the time with Chris Knoll, my client, said there were two leaks. One was on the bottom, and that was a major leak on the bottom on the line, and that was behind a pony wall. That's what Demlow testified to. That was concealed, and if the jury, and if we had the evidence...
It was up to the jury at that point to decide if that was in fact concealed.
But if we had, the point is on the spoliation, we were deprived at trial of an opportunity to show this jury that that evidence, that equipment, had we had that equipment, we could have tested it. We had over a year left, 15 months left. They just threw it out, didn't even tell us it was thrown out till months later. But if we had that at trial, we could have shown at trial, we could have shown that the causation, most of the water was coming from the line below, hence it was concealed, and it may have altered the outcome of the case.
And you argued that, and you presented evidence that there was a leak below.
Well, the judge...
And you had photographs. That's part of it. The second part is that you couldn't present the evidence that you're trying to present. But your client had photographs. There was testimony, there was a leak at the bottom. There were other things. There was contradictory testimony. So it wasn't that your client was completely denied the opportunity.
Well, there was contradictory, but the point is, had they not thrown out the equipment that was the subject matter of the lawsuit on issues of causation, we could have showed definitively that the major cause of the water was the line down below that caused it, and that was behind the pony wall and concealed. We were deprived of that opportunity.
But you did present evidence that there was a leak below. You presented argument, you presented testimony, and we're looking at an abuse of discretion standard, that Judge Viola abused her discretion in denying this.
Right, we provided that evidence, but they put Kellner, who wasn't there, who arrived 45 minutes later, to cloud and obfuscate the trial record by saying there was one leak, it was at the top on the line, and that's what was unjust at trial, because I had no way to confront that at trial. But if I could, I want to go to the other issue. The other issue, okay, I'll take 1 minute to tee this up. I'd like to reserve perhaps 3 minutes. But just to tee this up, the other issue is the jury instruction of notice of strict performance. The evidence was clear at trial that there were routine letters sent. The bills went out. They had water bills in there that were disputed. There were routine letters went out. Kim Miller said, well, she mailed it. Even though she communicated by email, she would send the routine letter. The key routine letter on default was September of 2018. Another routine letter, it goes to the wrong address because the landlord had the wrong address in the lease. Noel doesn't get it. Rick Obel, who's a California attorney, who's their CEO for the landlord, when they sent that notice out, they said it was $11,500 was due in September. They locked out in October. They had received prior routine letters 3 or 4 times, lulled my client, going back and forth with the water charges, lulled my client, got my client off guard, because then they would accept the rent a little bit late, accept it, keep going, and then quibble over the water charges again. They did that 3 or 4 times. That's clearly in the record. Then in September, she sends a routine letter to the wrong address, and then in October, they lock them out. Rick Obel, after the fact, does a review of the file. It's all in here. He admits, he says, well, we have a policy of if there's substantial compliance, we don't lock out. He looked at it and he said, that last default letter said 11.5, it should have said 10, we
Your
overbilled.
client had been locked out before. Your client knew that
That's
this
right.
landlord locks people out.
Right, so I'll try to reserve 3 minutes and come back.
Well,
but
you only got 2.
I've only got 2, and I'll take
All
those
right.
2 minutes and I'll come back.
All
Thank you.
right.
Morning, Your Honors. Ryan Bird on behalf of the appellee, Oxnard Commerceplex LLC and AZ EJM Land Holdings LLC. For clarity, I'll refer to them as EJM or appellees for the court. May it please the court, this case involves a commercial lease agreement, and I'm going to focus on a few of the issues that were raised so as to not reiterate my brief. When it relates to spoliation, since the majority of the argument was on spoliation, I think it's important to note that this water leak occurred in 2016. The tenant was in possession of the premises until the lockout on September 28th of 2018. So in addition to the litigation aspect of discovery, the tenant in this case also had the opportunity to inspect those lines, inspect the water leak at that time, as he was being billed for the charges and the reimbursement of those charges. In addition,
Excuse me, counsel?
yes, Your Honor.
I think the period of spoliation that's most relevant is the post-filing period, even though there are duties, as your opposing counsel pointed out beforehand. So just to be really clear, and it's not in the record, so I get it, in either side's initial disclosure statement, was the disposed of object listed as a trial exhibit?
It was not, Your Honor.
Okay, thank you.
The water heater individually was not. There was references in the facts about where the water leak occurred, what occurred during that day in 2016 about the water leak, and there was language in there about how once this water heater was bypassed, there was no longer a water leak. So at that time, the tenant, after the water leak, never had hot water to their suite, and the leak stopped.
Well, the disclosure statement has a narrative of the fact and the law around it, but it also has a part for anticipated trial exhibits. I just want to be crystal clear. You didn't list and they didn't list, to the best of your memory, though it's not in the record, this object that was disposed of as an anticipated trial exhibit, correct?
Correct.
Thank you.
I understand there were some photographs of the water heater that were submitted, is that correct?
Correct.
Okay, and photographs were just from your client, or did both sides?
They were submitted by both sides. They were part of the trial exhibits. Some of them were taken on the date of the actual leak itself.
And were these photographs submitted as part of the disclosure statement?
Yes, they were, Your Honor.
Okay.
In addition to, real quick on the spoliation, as the court determined and as the case law shows, there has to be an abuse of discretion. In this case, it's our position that Judge Viola, hearing all the facts in the case, made a proper ruling and didn't abuse her discretion in refusing to give a negative inference. There was no intentional bad act on behalf of the appellees regarding spoliation of that evidence. There was no request to retain that item. There was no request to inspect that item. At that point, a Murray Demlow, I believe's deposition was taken regarding the water leak. Mr. Kellner's deposition was taken regarding the water leak. And there at no point was there a request. So in my position, there was no bad faith on the part of the appellees regarding the water heater, nor was there any prejudice to the appellants at the trial. They were able to view those photographs, take witness testimony, and the jury, reviewing all that information, the evidence, was able to come to a conclusion that the appellant was liable to the landlord for the breach of contract. As it relates to the ambiguity, our position is that the jury never got to that second part of the jury instruction. This lease was a commercial lease agreement negotiated, controlling over the parties, and involved two commercial entities who had the opportunity to negotiate that lease and to enter into it. 6.03 and 6.04 of that lease properly set forth the landlord's maintenance obligations and the tenant's maintenance obligations. In addition, 6.03 says even if the landlord does it, they're entitled to reimbursement from the tenant. So in our position, there is no ambiguity as to who's responsible for these charges, whether it's concealed or not. In this case, the jury found it wasn't concealed. They could see it. Even the appellant's principal said when he came in, he could see the water hitting the wall. So in our position, there's no ambiguity regarding who was responsible for the charges associated with the water leak. That water heater only served the tenant's premises, and once it was bypassed, there was no more leak.
So, counsel, let me just ask with regard to the ambiguity, or the alleged ambiguity. Both sides could have asked the court to rule on whether or not concealed was ambiguous. Fair statement?
Yes, Your Honor.
And did either party move for summary judgment on that issue or ask the court to resolve it?
Not on that issue specifically. Both sides did move for cross summary judgment against one another. Court found that that was an issue of fact to be determined by the jury whether or not it was concealed in the lease.
And the parties ended up agreeing. I think there was some back and forth, but ultimately there was no objection to the jury instruction as given.
Correct.
And that jury instruction told the jury to look at the evidence, decide what it means, and if you can't, then we get to the second part that you referenced.
Correct.
All right. Thanks.
As it relates to strict performance, it's our position that strict performance is not required. The lease agreement is the controlling document between the parties. 13.07 of that lease agreement contains a non-waiver provision. That provision specifically states that all waivers must be in writing and signed by the waiving party. That's not the case in the facts presented to the jury. Landlord's failure to enforce any provision of this lease or acceptance of rent shall not be a waiver and shall not prevent landlord from enforcing that provision or any other provision of this lease in the future. So regardless of landlord's past actions, regardless of even an oral statement, which is not the facts of this case, 13.07 of the lease does not require strict performance. The landlord is free to exercise their remedies on their lease. Sorry, Your Honor.
Counsel, there is case law in Arizona that says even with a provision like that, a landlord can still waive, and they can even waive their requirement that it be in writing.
Yes, and those cases all reference an oral assertion or some evidence that the landlord did an act to extend that deadline.
To affirmatively
Correct.
waive it.
And in this
But
case,
it's not that it's not a waivable situation.
Correct.
Their argument is, under the facts, given what happened, the landlord waived it. But isn't that a fact issue for the jury then?
yes, Your Honor.
Okay.
And even so, when you look at the facts of this case, that letter went out on September 13th of 2018. It was addressed to the notice, address, and the lease that was provided by the appellant's principal. It contained a reasonable...
Well, because I know we construe against a drafter, but their executive, chief executive officer, I forget the title, signed that lease, which basically agreed that that was the address.
Correct. There's also a trial exhibit with an email from Mr. Noel himself, or actually, I'm sorry, Your Honor, it was to his broker. His broker forwarded it to the landlord that had that address listed. That's the address that went in the lease. It's a trial exhibit. If the court wants, I can get you the exact trial exhibit number, but that evidence was in the record, a lease or an email directly from Mr. Noel, the principal of the appellant, with that address. That got inputted into the lease. He signed it. That's where all the communications had been going. The statements prior to that also were going to an email address that he acknowledged is his email address.
Counsel, is there,
Can I just do a real quick follow-up on that? But they disputed it. The jury heard the dispute and resolved it the way they did.
Correct.
Okay, I'm sorry. I just want to make that clear.
I was just curious that there were some mention in the record about there being notices given to that address and then signing for it.
Yeah, Your Honor, it's we later learned that it's I believe a UPS facility or a FedEx facility, one of those mailbox places. And I guess we learned this after the fact. Whoever is on duty when those letters, they signed for it. So Mr. Noel, during testimony, wasn't able to indicate who signed for it, but we do have a signed receipt that it went to a specific box.
Okay.
So when you look at the strict performance, we have the September 13th letter that went out. It's important to note that they have put a reasonable time frame in there for the tenant to pay, 3 days, which the case law says you have to give a reasonable opportunity to cure. It also included a reinstatement of the time is of the essence clause. So in our position, we don't think strict performance is required because there wasn't any extension given. However, if the court feels that the case law was requires strict performance, our September 13th, 2018 default notice is strict performance. Under the cases, it had a time as of the essence clause reference. It had a reasonable time to pay. At no point after that September 13th, 2018 letter did we receive any communication from the tenant regarding their willingness to pay, regarding their dispute of the amounts asserted in that letter, and thus the lockout occurred on September 28th of 2018. The reference to Mr. Obel's testimony is not relevant in this case, as that is all after the fact. There was nothing during that time frame that Mr. Obel gave an extension to the tenant, made any affirmative assertion that the landlord would not exercise their rights under the lease to perform the lockout. And as the court indicated previously, this tenant had been locked out for failure to pay rent. As such, the appellees would request that this court uphold the jury's verdict and affirm their ruling against the appellant, and that the court did not abuse their discretion by refusing to give a negative inference. And I'm free to answer. Appellees also are requesting attorney's fees as a result of the appeal process. And I would ask if there are any other questions, I'm free to answer.
No, I think we're good.
Thank you, Your Honors.
Your Honor, I only have 2 minutes, so I'm just going to do a rapid fire here if I could. Thank you. There was a motion filed on the spoliation. I don't want to spend too much time on spoliation because I want to deal with the other jury instruction on notice, a lack of notice of strict performance in the record. But there was a spoliation motion. It was denied by the court. There was a duty to preserve the evidence. The real prejudice there, when we got to trial, they put the manager on the stand, Kellner, who was not there at the time, to testify about causation. I had no way, without having the equipment, to disprove what they were putting on at trial. That's the frustration that I'm trying to articulate here this morning. I had no way to meet it with the equipment to show it was the line at the bottom, which was behind the pony wall. The other one is the instruction on notice of strict performance. Now, the default letters were all routine. They went out, they were mailed to that P.O. box, never got to Knoll, even though there was testimony, undisputed that there were emails. Those were routine, they were the same. The last one, the fourth one, with the water charges going back and forth, was September. They did a lockout the following month. Obel came in after the lockout, admitted, he testified that that last bill was incorrect. It was $1,500 over. So they did a lockout on an admittedly incorrect bill, no notice of strict performance. They put the tenant off guard. Obel testified that he said he considered doing a notice of strict performance, quote, "That's our policy across the board after careful consideration," end quote. He's their CEO. He was quoted at trial, he said, he admitted that it was double billing and a billing error in September. He admitted that.
And counsel,
and he testified to it was $1,400 over. So that's our position.
Thank you, counsel. We appreciate the oral argument, appreciate everyone's preparation here today. We will take the matter under advisement. We will issue our ruling in due course. Thank you, folks.
Thank you.